Good morning, everyone. Welcome to Terra Firma's webinar on common good. This is the second in our series of 2021 webinars. There was a webinar on community right to buy and asset transfers, which is available on our YouTube channel. Today we have two speakers, Scott Blair and Dennis Garrity, who will introduce slightly more fully in due course. Common good might be considered to be a peculiarly, well, it is a peculiarly Scottish concept and might be considered to be slightly obscure. England has its village greens and common land, but common good applies not just to open spaces, but buildings and also funds. Some might even say it's a somewhat obscure topic, but with recent cases, it's perhaps lost that obscurity. We're delighted to have so many of you joining us this morning, and we put that down to the quality of the speakers rather than we're in the third month of lockdown this year. We have more webinars coming up. Immigration on the 1st of April, employment on the 8th of April, property on the 29th of April, and planning judicial review on the 13th of May. The details aren't up on our website yet, but they'll be up in the next day or two. If you have any other ideas for other topics, please let Emma, our practice manager, know, and her details, contact details will be on the last slides. To say that all the slides will be emailed to you after the event, and a recording of the event will be uploaded on the YouTube channel. Scott Blair has also produced a background text, some fundamentals of common law. For those of you that don't have time to read Ferguson's full book, it's a very useful sketch of the issues, and it also is an updated sketch of the issues. There will be a link to that on the email after the event as well. And we are more than happy to take questions. We're hoping to have Scott speak to about 11:30, Dennis speak to broadly 10 to midday, and then to have question and answers. And there's a question and answer function on the screen if you search for it, and I will try and moderate any questions that come in. I'll remind you of that as we go along. So over to Scott. He specializes in licensing law, public law, administrative law, local government law, social work law, animal welfare law, and human rights law. Of particular importance today, he's ranked as a leading junior counsel in Chambers and Partners for Administrative and Public Law. They say, and I'm sure he is, very creative, does high profile, interesting and novel work that navigates uncharted legal territory. He's friendly and approachable and very helpful and able. And also I should add that he's one of two of the premier licensing advocates in Scotland. So Scott, over to you to introduce the talk today. Thank you very much.
Thank you very much for that introduction, James. That's extremely kind. Yes, indeed, some might think common good law is a relatively obscure topic, but if anything, the recent hearing in the Inner House in the Guild and Angus case suggests that that is not entirely the case. What I would like to do today is to go through some fundamentals of common good property. And in saying that, I immediately recognise that my talk is headed Fundamentals of Common Good Property. And the next speaker, Dennis Garrity, poses a question, do we even have something called common good property? So we seem to have something of an existentialist crisis at the start of the seminar, but hopefully between the two of us and with James chairing, we can perhaps cast light on what we mean in terms of our respective positions. I'd like, in terms of the first slide, to perhaps take you through some basic stuff. What is common good property? Well, put short, it is a fund of money or assets, movable or heritable. Typically in the case law, we are dealing with heritable property, that is land, administered by a Scottish local authority in respect of the area of the former borough to which that authority relates. Now, of course, up until 1975, when the boroughs came to an end, the system of local government in Scotland was divided in a way that's quite different from the current arrangements. And that really harked back to the Middle Ages, whereby boroughs were the administrative unit for local government in Scotland. And over the years, particularly during the 19th century, we see a modernisation of that system. And ultimately, we get to the reforms in the Local Government Scotland Act, 1973. The question of what is common good then is not necessarily related to simply land. It can relate to a whole range of assets owned by the borough before the reforms in 1973, when the borough system ended. It could include things like artworks. For example, I'm aware that Angus Council holds a painting by Peter Bruegel the Younger as part of its collection, and suffice to say, a painting of that kind is likely to be of considerable value. But for the purposes of today's talk, the focus, I think, has to be very much on land that is held in the common good. We've had some notion of common goods in Scotland since at least 1491. There is on the statute book a thing called the Common Good Act 1491. That's still in force, although I don't think anyone ever refers to it. But we get a lot of our thinking about common good law from a series of cases over the 19th century and the early to mid 20th century, culminating in a case called Ruthin Castle, or more properly, Banff, Borough of Banff against Ruthin Castle Limited in 1944. I'll come back to that later. The 19th century cases are still referred to. They are still important. They set out the broad parameters of common good. And you do need to be a bit of a legal archaeologist to have a handle on what common good might mean. There are a number of broad concepts I want to work into this introduction. There's a case called Portobello, put short, that's City of Edinburgh Council case, where the Residents Association in Portobello contended that the decision of Edinburgh City Council to turn a park in Portobello into a secondary school breached the duties of the local authority in terms of common good law. And that case is referred to in the notes, and I'll come to it later on. But it does give some content to the view that within the concept of common good, there exists a notion of fiduciary duty. Those of you who are trust lawyers, and those of you who are perhaps interested, lay people with an interest in law, will understand that fiduciary duty, in essence, means the obligation on the part of trustees to put the interests of the trust as the first and foremost consideration in any decision they have to make. Now, while I wouldn't go as far as to suggest that common good is a form of trust, I think the case law makes that quite clear. What is the case is that both the Portobello case and the Guild against Angus Council case, which I will touch on and which Dennis will deal with in some more detail in his talk, both, I think, do stress this notion of primacy of common good and of the need for the local authority to have regard to duties in respect of maintenance of the common good fund. Now, that takes me really on to another broad area, which is maintenance of the common good fund and also best value obligations. One of the difficulties that I would suggest that local authorities have in the world of common good is that things have moved on somewhat since the borough system, and indeed since the 1975 repeal of the borough system. In particular, we now have a system of modern local government finance. We now have the obligation to maintain on a continuous basis best value in the discharge of local authority functions. And one of the tensions inherent in the common good system is the extent to which this notion of fiduciary duty outweighs or can supplement the notion of general local government finance, that functions have to be developed and delivered with best value considerations in mind. And we see something of that in the Angus case again, where the Inner House looks at accounting practice within local authorities and ultimately comes to the view that whatever the accounting practices may be internally in a local authority context, internal accounting is not a safe or reliable guide to determining what is or isn't common good or how common good should be approached. I want to touch on a series of general points which relate to what we mean by common good property. I also want to, in that part of this slide, discuss the distinction between alienable and inalienable common good. It's a somewhat clumsy phrase, alienable, and indeed the court in the Angus case makes the point. The language is a bit old-fashioned, but there we have it. I think the starting point is to say that conventionally, all property inherited by a modern Scottish local authority in 1975 from the borough is common good. So the starting point seems to be that everything is common good unless it falls within a series of exceptions. So if you're imagining a Venn diagram, as it were, everything is common good subject to these exceptions. Okay, having got your head around that, the next thing to grasp is that once you've identified what is common good, then within the concept of common good itself, we have alienable common good and inalienable common good. Okay, now what are the exceptions to common good? Well, I think one has to look at the Ruthven Castle case from 1944. It's not the easiest case to read, and the opinions of the court, which included the Lord President Cooper as he became, are not necessarily wholly reconcilable. And if one looks at Ferguson's book, I think you can see why I say that. But nevertheless, the received wisdom seems to be that exceptions to property being common good are as follows: where the property is held on a special trust, or where it's acquired under a statutory purpose. So in essence, what that seems to suggest is that a lot of property held by a local authority might actually fall out of common good because much local authority property is acquired under statutory powers. But I would also suggest it's not necessarily that straightforward, because of course, a property acquired under statutory powers may ultimately be used for something other than the statutory power under which it was acquired. And I'm aware from my own practice of situations where, for example, land might have been acquired for the purpose of building a school, but that school was never built. And in fact, what happened was the site was turned into a park. Which takes me really to the next point, subject to the special trust point, of which there are few examples in the case law. Identification of common good generally involves one looking at a range of factors. Normally, the title for the land in question will give a pretty good steer as to whether or not one has a common good purpose. So typically, one will identify from the title whether the property is acquired for a special purpose for the benefit of the inhabitants of the borough. Often when one is dealing with land such as a park or a recreational area, that's a pretty easy exercise because the title itself should give an indication of what the disposer of the land intended, typically using words, for example, this land shall be used as a public place of recreation in all time coming and shall not be used for any other purpose whatsoever. That sort of thing is a pretty good indication you have a common good title. But sometimes the title is silent, and one has to examine the history of the land in question and identify whether the local authority has dedicated the land to a particular common good purpose. And that might be an express dedication. You might go through the council archives and identify from its records that the council has dedicated the land to a particular purpose. Equally, it may be a purpose that has arisen over time through a notorious use of the land by the public for a public purpose, such as the playing of a game, the holding of markets, and such like, and so forth. And that suggests again that a lot of this is rooted in 19th century notions of what the public use land for. We see all of this in the Rutland Castle case, which is worth a look, as I say, where the court does draw out this distinction between common good as a whole and the exceptions to it. Dedication of land in terms of the common good account of the council is an unsafe guide as to whether or not land is in fact common good. We see that in the Angus case, where the court noted that the fact that the leisure centre in question was not listed in the common good account did not prevent it from being common good. So again, the formal classification of land by a local authority as common good or not common good in accounting terms is only one factor in determining whether one has common good before one even goes on to address the question of whether it's alienable or inalienable. Now, what do I mean by that, alienable or inalienable? Well, if one has common good, within it there are two categories. Alienable common good is property which can be disposed, alienated, or changed in use without the need for judicial consent from the sheriff or the court of session. Inalienable common good, or property in relation to which a question arises in terms of section 75, subsection 2 of the Local Government Scotland Act 1973, is land where a question does arise. And typically that is land where one has a dedication to a public purpose or a public benefit. Now, this takes me neatly to the next slide, where in considering the question of common good, there is the underlying duty on the part of a local authority to have regard to the interests of the inhabitants of the former borough. Now, we see that from the 73 Act, and we see that from the local government reforms in 1994 as well. A duty to have regard to something in dealings with the common good is not a duty to follow. It is not a duty to simply adopt a position advocated by people who live in the area of the former borough, but it is a duty to have regard to those interests in decision making. I think it's fair to say that that duty has been significantly enhanced, though, by the Community Empowerment Scotland Act 2015. One of the complaints that many members of the wider community had before the 2015 Act was that local authorities were in the habit of, frankly, not being transparent or upfront about what they were doing with common good property. Now, whether that was right or wrong, that was certainly the perception. And this legislation, which of course also includes the provisions on community asset transfer, has brought about for the first time a statutory duty to consult in relation to proposals by an authority to dispose of or change the use of common good property, particularly land, but all common good property. Now, this really follows on from the duty of the local authority to have a register of common good property. Now, most registers are incomplete and probably will never be completed, but there should now be some kind of record in your local authority area setting out what the council at least considers the common good might be. Now, just how wide are these obligations? And that really takes me to the Angus case. That is Guild against Angus Council, decided by the Inner House in August of last year. And again, Dennis is going to speak about that in more detail, and I rehearse a lot of what I have to say in my detailed notes for this talk. Long story short, Angus Council wanted to demolish a 1970s leisure centre built on a park in Forfar. Local residents were concerned about this, and in particular, the failure of the council to consult on the question of demolition before the demolition took place. And they raised a judicial review against the council, and they sought an interdict, that is an order from the court preventing the demolition from occurring. Now, the judge who heard the case first time round took the view that no question arose, that the demolition of a leisure centre was not a disposal for the purposes of the consultation obligations, and accordingly the council were entitled to proceed with the demolition, notwithstanding they had not consulted on it. She also took the view that the building itself was not common good, albeit the land on which it was built, the park, it was. We then get to the inner house. The residents were determined to push the point further. We then get to the inner house, and my learned friends, Mr. Findlay, our chair, and Mr. Garrity appeared for Angus Council in this matter. The Dean of Faculty appeared for the petitioners and reclaimers. We have a 2-1 decision in the inner house. Lord Mingus delivered the main opinion, the Lord President supported his opinion, and Lord Malcolm, it is fair to say, didn't agree on much of what the other 2 judges had to say, if anything. So a real sharp division of opinion. What's striking, though, is when one looks at the majority opinions, both stress the strength of the consultation obligation. They emphasize the use of the word empowerment. They also stress that the notion of what is a disposal and what is a change of use should be construed broadly and are not necessarily confined within the meaning of disposal or change of use that one might find in property law or in planning law. They took the view, consistent with earlier case law, such as the Waddle case from the 70s, that knocking something down was, as a generality, a disposal of property, and if it was part of the common good, that was a disposal of common good. Now, it was part of the common good because the building in question, having been built on common good land, itself became common good. Now, that's quite interesting because the leisure centre was built over the course of the 1970s, and of course, by 1975, we no longer have, on the face of it, the ability to create new common good property because the borough system has gone. But there you have it. Along the way, the court was careful to make the point that not every change in use would necessarily give rise to a consultation obligation. Lord Mingus, for example, posited the scenario of a local authority changing let's say, a basketball court being substituted for a tennis court on a park, and suggested that whether there was a change of use is a question of law and a question primarily of fact. So it's not necessarily the case that every change in a common good site engages these consultation obligations. It's a question of fact and degree. What is fair to say, though, is that insofar as one can distinguish what is a change of use that engages common good consultation obligations and what is an appropriation for the purposes of judicial consent, there is going to be room for debate. And the reason I say that is that as I read the Angus case, it seems to suggest that the consultation obligations apply to common good property disposals or changes of use in themselves, regardless of whether or not in due course they would be regarded as disposals or appropriations to another use for the purposes of judicial consent. In other words, the consultation obligations appear to apply to common good property generally, and not just the category of inalienable common good. Now, that I think is potentially problematic for local authorities, because if that is right, then it does seem to suggest that consultation obligations are considerably wider than might be thought. And that's really where Lord Malcolm takes up the gauntlet. And he seems to say, in a fairly well-reasoned and robust dissenting opinion, that many acts of a local authority are not in truth appropriations of common good. They are simply management decisions, and a decision to knock down a leisure centre and return the park to a parkland site was simply a management decision. Section 104 wasn't engaged, and there was no change in use. He also seems to be concerned about the extent to which the 2015 Act may appear to widen the concept of community involvement beyond that which was quite properly intended by the legislation that was passed by Scottish Parliament. So perhaps, James, if we could move on to the next and final slide. Thank you. I've been flagging this up in advance: disposal, alienation, and appropriation of common good property. If you have inalienable common good property and you wish to dispose of it, to alienate it or appropriate it, that means change the use for it, then to act lawfully, the local authority ought to apply for the consent of the court. Now, in the Angus case, the court, the local authority didn't do that. And what we see there is an example of the use of judicial review and interdict by concerned residents to come to court and say, look here, we have a situation where, in fact, the local authority ought to have consulted, and in any view, this was a disposal. Therefore, the local authority have acted unlawfully. We saw an example of that earlier in a case called Kirkensey and Port Seaton Community Council against East Lothian Council. And we now have at least 2 Scottish cases where concerned residents or the Community Council have taken action against a local authority who they consider have not followed the law. And suffice to say, it has to be said that the Angus case, if anything, is simply going to heighten the possibility that that may happen again in the future. I would also suggest that as a result of the Angus case, it may be that local authorities may feel that they have to go out to consultation on matters which perhaps in the past they wouldn't have consulted on, because there might be a risk the court might take the view that there was a relevant change in use in a particular case. So the question of when does a question arise or not is really primarily determined by our good old friend, does this particular title have the character of common good where a question arises? And that's really the issue of dedication to a public purpose, whether by express grants, implication, or practice. And the cases are replete with examples of this. We see from the 19th century, for example, in St Andrews, part of the area of St Andrews used for golfing. There was an issue there about whether or not part of the seafront of St Andrews was part of the common good because the residents used it for golfing. We have other obscure cases from the 19th century where people wanted to bleach their clothes on the bleaching green, but the council wanted to build a stables for police horses on that site. That was also held to be an alienation of the common good. Now, these are pretty old examples and they are pretty obscure. And in reality, in the modern world, typically what one will be concerned about is something which has a clear public purpose, typically a park, an area used for recreation or leisure. There may be questions arising in relation to public monuments, but also in relation to civic assets generally. Town halls, civic buildings, public squares, public spaces will often be examples of common good, even if they are not themselves used perhaps for leisure and recreation. So this notion of dedication to public purpose is very much at the heart of when a question might arise or not. Of course, common good land can lose its character as common good. Now that's a bit of a grey area, but it does happen. Let's say, for example, a local authority building a town hall is not used for years and years and years because the council has moved its business to another facility. The council now wants to knock the town hall down and build, let's say, a leisure centre on the site or something else? Does a question arise or not in those circumstances? Now, on the one hand, the town hall is common good, but on the other hand, it's never been used for that purpose for a number of years. So there can be situations where one has, on the face of it, common good, which is inalienable, but the character of the common good has been lost, for example, through lack of use, through change of use, where the public have not objected to that change of use, where there has been dedication to another purpose. We see an example of that in the Cockenzie case, where the proposal was to knock down a swimming baths built in the 1930s, but replace it with a new leisure centre. In that case, Lord Osborne held that whilst the swimming baths had been inalienable common good, they had lost that character simply because a substitute had been found. Now, I want to posit the question there and ask whether that line of thinking might still hold good in light of the Angus case, because what the court there seems to say is that many changes in use will engage consultation obligations. So regardless of whether or not the change might give rise to a question under section 75(2) of the 73 Act, it may at the very least still engage consultation obligations under section 104 of the 2015 Act. I want to just really finish up with a couple of points by way of emphasis, and to pick up a point I didn't fully address earlier. Acts falling short of a disposal, alienation, or appropriation. Read Lord Malcolm in the Angus case. He stresses that acts of management are not acts which amount to disposal, alienation, or appropriation. Now, I think it's fair to say neither Lord Mingus or the Lord President would differ with that as a general proposition. On the facts of that case, they considered the demolition of the leisure centre to be a disposal, and I think one can see why that might be, on the face of it, a logical outcome. There remains, though, scope for debate as to whether or not every act of management of common good property amounts to appropriation. And there must, within this notion of act of management, still be a fairly broad spectrum of activity on the part of a local authority, which does not amount to a change in use. To take up Lord Mingus's point, can it be said that changing a tennis court for a basketball court in a public park, which is a place of recreation, is a change in use? He would say and suggest no. He suggests a common sense approach should be taken to what is a change of use. And in his view, and in the view of the Lord President in the Angus case, when you knock down a covered leisure centre to return it to a public space, then that is plainly a change in use. Yes, public space is still recreation. A leisure centre was recreation. But the reality is that the character had changed greatly by taking the building down, and sports and such like could not be conducted within a weatherproof space. The last point I want to make, as I'm conscious of the time, is that one should not also overlook the continuing residual character of feudal burdens. Now, of course, feudal burdens went with the abolition of the feudal system and the Title Conditions Act in 2003. But it strikes me as correct to say that insofar as one has common good property subject to title conditions, a question may arise in that sense as to whether the title conditions remain enforceable at the hand of the superior, even if, for the purposes of what is common good, no question arises in strict common good terms. And there are interesting questions to be discussed and to be debated as to the extent to which standard title conditions that one might find in, let's say, the title to a public park are simply obligations as between the superior and the local authority, as opposed to obligations that residents can rely on to claim an interest in any possible change in use that might impact on those title conditions. But that perhaps is a subject in itself. I hope that scamper through what I think are the fundamentals of common good will refresh those who are already aware of common good law, as a recap on their knowledge and an updating of their knowledge. For those who are coming to this for the first time, I hope it's been a useful overview of common good. And as I say, in the time available, I've not been able to go through my detailed case notes, which run to the best part of 20 odd pages. They are available on the Terra Firma website. And if nothing else, if Netflix runs out of options for you, they might be worth a read on a quiet evening. Thank you for listening, everyone. I am, of course, happy to take any questions at the end. In the meantime, if I could perhaps hand back to James.
Thank you very much, Scott. I think you've affirmed my point that common good law has its peculiarities, but you've rendered it less obscure to those of us that have been listening to you for the last half an hour. So I'm very grateful for that. You'll note there's one question that's come up about local park tax, and I'll come back to that
yes.
Question and answer session, but if you want to have a look at that. I'll move on to Dennis Garrity now. Dennis called to the bar in 2014, but prior to that was a partner at Brady's for 14 years and was recognised whilst there as a leading practitioner in the field of commercial real estate law by Chambers and Legal 500. He's now ranked band 1 in terms of real estate litigation. Apparently, he's a very experienced junior with expertise ranging across the full spectrum of property litigation, including damages, easements, landlord and tenant disputes. His background as a property solicitor gives him unique breadth of perspective. Sharp, astute, and really good to work with, it says. Well, I can attest to that because having worked with Dennis in Guild and Angus, and even though we ended up 2-1 down in the inner house, he is very good to work with. So over to you, Dennis.
Thank you very much, James. I should say as well, good morning, everyone. James is operating the slides for me, and we shall see how this goes. So I'll start off with the title. Is there such a thing as common good property? And Scott's also alluded to some of what I might say during this talk, and Scott and I discussed beforehand how we might allocate the talk, and it came as no surprise to me, having known Scott for over 30 years, that A, he took the longer speaking slot, and B, that he has boxed me in to speaking about the Angus case. And it's a case that James and I, let's just say, we assisted the court in coming to the particular outcome in that case. It clearly wasn't entirely to our liking at the end of the day, but it is a really interesting decision. I'm going to run through the property aspects in particular, and also, if I have some time, I'm going to speak about some of the implications of the decision, which I think are incredibly important. First of all, we have on screen Lochside Leisure Centre for Loch. Actually looks rather attractive there, if you like, monolithic architecture, but it is a building, it is on common good land, and what that picture doesn't show is that it hasn't been used for a number of years. Apparently there are some structural issues with it, and as Scott said, the council wanted to demolish it. So in the best government fashion, next slide please, James. This led to the case of Guild against Angus Council, and it was reported in the Outer House and also in the Inner House. And again, of interest is the fact that the Outer House judge sided in many ways with Lord Malcolm in the Inner House. And if you take the judges collectively, we actually have a 2-2 decision. But we won't dwell on that. And the majority in the Inner House was against the submissions that James and I put forward. Concerned Lochside Leisure Centre at Forfar Loch within Angus Council boundaries. And an important point is that it was agreed that the land in question was common good land. And it was acquired in 1954, and it was acquired using common good funds. So there was no question about that. The point at issue was whether the building upon the common good land became part of the common good land, became part of the common good as a result of that. And in the Outer House, there seemed to be some acceptance on the part of the petitioners that this was a natural split, that the land was common good, but the building wasn't. And the Outer House decision proceeds on that basis. And it did so on the basis that the council didn't have the centre itself, the building, on the common good account. There was a notional rent in place between the common good fund and the general funds of the council. It was built in the 1970s without using common good funds, and therefore the position before the Outer House very much was that the land was common good, the building wasn't, and the Outer House decision proceeded on that basis. As I've said at the bottom there, the council's position was not challenged in the Outer House on that basis. So next slide, please, James. So we come to the Inner House, and the petitioners, for whatever reason, decided to take this point in the Inner House, and in saying that, well, actually the building must form part of the common good because it was built on common good land. And we see there the opinion of the Lord President, paragraph 2. First, unless structures which are built on the land are held under a separate title, they will be regarded as having acceded to that land and thus become part of it and the title which relates to it. This principle applies to common good land. Full stop. Goes on to say, the Lochside Leisure Centre is therefore part of the common good land. The accounting practices of the respondents and their intentions are irrelevant to this issue. When I was preparing this slide, it did occur to me that the Lord President effectively finds against us in paragraph 2 in this respect in its totality, which is a bit of a disappointment as council reading through a decision. And Lord Mingies then goes on with the larger part and says the principle that the owner of the land is also the owner of the buildings erected thereon by accession is one recognised by the institutional writers. And he cites Bain against Brand, or Brand's trustees case. For fixtures and fittings more generally, the case of Scottish Discount Company against Blinn is one to look at in addition to Bain against Brand. And he also, Lord Mingies also confirms this point that the notional tenancy, the internal accounting between the Common Good Fund and the council funds more generally is of no relevance. And this is a really important point. And it's the implications of the decision for this particular aspect of council practices that I think is worth for further exploration. Next slide, please, James. Now, we come on to the decision, the dissenting opinion of Lord Malcolm. And the position adopted by the Lord President and Lord Mingies is entirely standard. It is entirely standard property law. And to that extent, it's not really possible to argue with it. It's property law. That law has been established for quite some time, the institutional writers onwards, and therefore what on earth were we doing in this petition? What were we doing arguing against this? So it's worth focusing on the dissenting opinion of Lord Malcolm. And there at paragraph 48, so at least we've got this far into the opinion and someone's actually supporting us. The question in this reclaiming motion is this: does the proposal to demolish the Lochside Leisure Centre, sorry James, I can't see that slide there. Thank you. Does the proposal to demolish the Lochside Leisure Centre amount to either a disposal of property held by Angus Council as part of the common good, or to a change in the use of such property? I agree with the Lord Ordinary that the answer is no. Goes on to say, I do not accept the proposition that since the centre was built on common good land, it must also be held by the authority as part of the common good land, as part of the common good. And so clearly a stark contrast between the decisions, and the question really is it possible to reconcile them? Because Lord Malcolm is clearly saying the answer is no, it's not part of the common good. whereas clearly Lords Carloway and Minges are saying quite the opposite. So next slide, please, James. And Lord Malcolm, who common good followers might remember the capital buildings or capital projects buildings case, has shown an interest in common good for some time, and he elaborates at quite some length within the Angus Council decision as well. And he says the key distinguishing feature of common good, and in particular inalienable common good such as Forfar Country Park, and I've made a comment there, that was not an admitted point, and it may be of further relevance for the council in due course, but it's noted there that wasn't admitted. Anyway, the particular feature here is that the particular interests and rights of the intended beneficiaries, the inhabitants of the former borough. This might also be seen as a separate tenement, property tenement, or perhaps something equivalent to a right of servitude. One might classify inalienable common good land as a type of property extra commercium, in the sense that here the park, and the park alone, is held in a form of public ownership. All that said, it is probably sui generis of its own kind. So here Lord Malcolm's just saying, well, actually, this is something completely different from standard property law. We're not looking at property as we normally would. It's an entirely different category of property. So James, if we could have the next slide. Now, I thought at this point I'd try to be topical. I did, when I was preparing the slides, think of Santa Claus, but since we're nearing Easter and the sun is out today in Edinburgh at least, here we have the Easter Bunny. Now, you're all obscured from me. I can't see any of you, so feel free at home to participate. If you believe in the separate categorization of common good property, put your hand up. No one will see you, that's fine. If not, keep your hands down. But really, I mean, it is a point. Does this exist or not? Does common good property exist? So James, next slide, please. And they've said, is that a question of belief in something that exists separately as common good land or common good property? Or does it stem from a misunderstanding? And I make no criticism of the judges in the Inner House when I say misunderstanding. It's obviously been interpreted in a different way, of accessions as discussed in the Magistrates of Banff case. And that particular word was used in that case and founded upon in the Angus decision. And what Lord Malcolm says is, I do not understand Lord Mackay in that case to have been using that term in the sense of buildings and fixtures exceeding to the owner of the solum. Rather, it was said in the context of additions to the original endowments of a borough. This was no more than an echo of the Lord Ordinary's mention of additional grants, supplementing the original grants made when the borough was created. And again, as Scott said, one of the points we made to the Inner House was that it's not possible to create new common good property at this stage. But that argument fell on stony ground, I'm afraid to say. But here we see the hub. Where is the distinction coming from? Accession in a standard property law term, or accession merely as an addition, someone giving something to it? And it was accepted that there was no intention of donation on the part of the council. In this case, donation of the building, the bricks and mortar, to the common good fund. So James, if I could move on to the next slide. And Lord Malcolm goes on to talk about separate ownership interests, the feudal system, which obviously has been abolished, etc. And again, harking back to the Banff case, and Lord Justice Clark Cooper observed the different categories of property that a chartered borough may competently hold, and distinguishing characteristics of the special category known as common good. So Lord Malcolm's categorizing common good property as different from standard property, and this quote there from the Banff case. James, could I have the next slide, please? So cutting to the chase, because I do want to raise the question of the ramifications of this decision. So is the answer to the question this: there is no such thing as common good property in light of the Angus decision, but rather it's merely a case that there is property that might form part of the common good? And I think that is the answer to the question at the outset in light of the Angus Council decision. We do not have a separate category of common good property, or in more topical terms, rabbits do exist, but the Easter Bunny doesn't. At the top of the slide, you'll see the case wasn't appealed to the Supreme Court, and I say sadly not appealed, not only because James and I didn't get to go to London to argue the point, but I do think the case has significant ramifications for accounting and finances within common good funds. And I've written out this morning, in case I have time, and I think it's worth doing this, a scenario for people to consider. Let's say a council held title to common good land. And let's say that on that common good land, it borrowed money or with its own funds built a shopping centre or another income producing asset. Let's assume shopping centres are still income producing. They may or may not be at present. But let's say a shopping centre income producing asset was built with the council's own money. And in that scenario, it would probably be the case that there would be a notional lease or tenancy arrangement put in place, and there would be a notional rent paid for the use of the land by the council into the common good fund. So far, so good. But now what we have in the Angus decision, or following the Angus decision, is the fact that actually the shopping centre is part of the common good. Full stop. There's no question about it, no debate. The shopping centre is part of the common good. And it follows, therefore, that there cannot be a legal fiction of a notional tenancy and a notional rent. And accordingly, any fruits of the land, i.e. rental income from the shopping centre, must, as a matter of law, flow to the common good. It cannot form part of the general fund of the council. And that is the true position that the decision in Angus leads us to. And not only is that the position as of the decision, but it's also the position for all time. The court wasn't saying, well, from now on, this is the law. The court is saying it has always been the law that any bricks and mortar on top of common good land forms part of the common good. And I'll just finish off with throwing this point out there. Does that mean that common good funds have claims against general funds for any income that might have been paid into the general funds previously? Is there an unjustified enrichment angle to all of this that people need to be considering as well? And it all becomes incredibly complicated. There are lots of other ramifications about management and consultation, which Scott's alluded to. But in pure financial terms and accounting terms, I think that's quite an important decision in and of itself. So I'll finish there, James, in the hope that there are some questions for us to consider as well.
Dennis, thank you very much. We have 10 questions. I think actually we actually only have 8, having had a brief look at them. And I think one of them raises the point you were just considering, Dennis. But I'll take the questions in order. I see it's now just before 12 o'clock. We'll aim to finish about 10 past 12. So we'll try and keep the answers reasonably brief. First question is for Scott. And that is, and I presume it is, whether land acquired under Local Parks Act would be common good land or whether it would be an exception from that.
Yeah, that's an interesting one. I've had a look at this in the past for a fairly large local authority, and it strikes me that land that's acquired under the parks legislation, 19th century in the main, and subsequent iterations of that, is not land that is common good. It may have a purpose that you might think is common good, it's public recreation, but if it's acquired under legislation, then it falls clearly within the exception in the Ruthven Castle case. That being said, you could, I suppose, have a scenario where land that was already a park, as it were, let's say a landowner, one of the great and the good of the Industrial Revolution, had created a public park, couldn't maintain it anymore, and it then becomes acquired under the local authority legislation. I'm not sure that one's been looked at yet, but I could see an argument that the land may have been acquired under local authority legislation, but it already had the character of, as it were, common law, common good. The only other point I would make is that insofar as anyone is concerned about the management of a public park acquired under parks legislation, then the remedy is likely to be ultimately one of judicial review of any decisions taken by the local authority in the management of that park. And that would raise questions of, did they act lawfully, did they act reasonably, did they act fairly in public law terms? But I don't think, on the face of it, land so acquired is likely to be part of the common good.
Thank you very much. I should say, as with all questions and answers, that we're not giving specific legal advice, but obviously we'd be happy to do so. The second question really picks up on something that Dennis was talking about, and I think there may be another question that deals with it too. The question is, would a common good fund be entitled to claim compensation from a local authority as a third party for works carried out on and or damage caused to common good land as a result of flood prevention scheme operations? So that's quite a specific point, but Dennis, over to you to give a response to that, if I can, in first instance.
I'll possibly duck the as a result of flood prevention schemes question at this point. I'd need to think about statutory duties, etc., and how that was undertaken. But in terms of common good land or common good property, I don't see any reason why a common good fund cannot assert its legal rights. If the question's really specifically related to flood prevention schemes, then need to think about, well, has that actually caused damage? What is the cause of the damage? And then consider the statutory powers under which the flood prevention scheme was constructed.
The may arise is not only whether the common good fund would be entitled to claim compensation, but whether they'd be obliged to compensation. It's a similar point to your point about rent from the shopping centre. If it's all part of the common good fund, those in charge of the common good fund should arguably be ensuring that they recover what is due to them.
Indeed, and that's the clearest of clear implications from the Angus Council case, that it is no longer feasible, it's no longer statable really to say there are different arrangements between different functions within the council in relation to common good assets.
Scott, I wondered whether you wanted to add anything here before we moved on to the next question.
Yeah, just very briefly, like Dennis, I would agree that given my recollection of exercise of statutory powers which cause damage, then you have to look at the legislative scheme, and the normal approach, I think, is a case called Hill, I think from the 1880s that looked at this in the House of Lords, is that no compensation would be payable unless the legislation itself made it clear that it ought to be payable. So you probably would have to caveat that type of scenario with the need to examine the type of legislation with which you're concerned.
Thank you. So if we move on to the third question, it's, and this may be for you, Scott, if anybody, in what way are cities treated differently for purposes of common good? Are they likely to have less of any common good land than other areas? And that's probably a historical question. So I shall pass that to you in the first instance.
Thanks very much. Yeah, I mean, you could trace this right back to the Local Government Scotland Act 47. And if you look at the schedule to the 47 Act, as one does of an evening, you will see there are distinctions between boroughs of cities and large boroughs and small boroughs. So historically, the treatment of common good varied slightly in terms of the old common good legislation in the 47 Act. I think it's fair to say, though, that for the purposes of treatment of common good under the 73 Act, there really isn't any distinction. What one has to do is carry out the same exercise of identifying, have we here land which formed part of the common good of the former borough, whether that was the borough of the city of Glasgow or the large borough of the town of Paisley or the small borough of the town of Forfar. All of those are of historical interest. I think the question of who's likely to have more common good land is broadly likely to be answered in favour of, logically, larger populations. Plainly, the geographical extent of Glasgow takes into its modern boundaries land which would have been comprised in a whole range of other local authority boroughs in historical terms. So you probably would find, as a matter of generality, that cities tend to have relatively more common good land than smaller communities. But that's by no means a conclusive answer. One can imagine in rural locations where landowners have dedicated large tracts of land to public purposes, even relatively small local authorities may have a fairly large common good portfolio. I'm thinking here, for example, I've experience of common good arising in Dumfries and Galloway, which in terms of population is pretty small, but in terms of geographical spread is pretty large. And there are large tracts of Dumfries and Galloway that undoubtedly fall within common good, and particularly inalienable common good, given the actions of landowners over the years dedicating land to public purposes.
Thank you for that. If we move on to the next question, I'm going to put up the last slide, which gives Emma's details in a moment, so that those who have to leave before we finish the day will have those details. The next question, before I do that, is a park acquired with common good status through practice had long lease granted in favour of a particular sports club. Would extension or renewal of that lease now occasion a public consultation? I don't see either speaker rushing to pick this one up, but I'm going to ask Dennis to give his initial view. It may not be possible to give, it probably isn't possible to give a comprehensive view on that, given the limited background details. But Dennis, over to you in first instance, then I'll call Scott in.
I think it's certainly arguable that consultation would be required because it's the entering into of a new lease that's presumably being contemplated, or even an extension of an existing lease is doing something with the land. It's, I think it's superficially attractive to say, well, we're just doing the same thing, so we're not actually changing anything. But I think the reality is, if it's a new lease, a new right that is being created in favour of a third party, then people should approach that carefully.
Scott, I wondered whether you...
Yeah, picking up on that, I mean, if that scenario, if the analysis that Dennis has offered there is correct, and I'm not suggesting for 1 minute that it's not, but if that is a possible analysis, then I suppose the next question is, would the authority require to go to the court to get consent for that purpose? But it seems to me there has to be an argument the other way, which is at that stage, there may be a question of whether a question arises, because on that view, whilst one may have common good land in the generality, it may have lost its character as inalienable common good land because of a history of prior granting of leases to an occupant sports club. So you could get into this interesting area where on one view, there may be a duty to consult, and I express no concluded view on that myself. But even if there is, it doesn't necessarily follow that one would require to go to the court to authorise the lease if, in fact, over the years, this arrangement has been in place over a number of years. It may have lost its character as inalienable common good land, even if it still remains common good for consultation purposes.
Yes, I would add that that would seem to me to fall probably into Lord Malcolm's category of management of common good land if you're simply renewing a lease to a sports club. I see Dennis wants to add something.
I'm not sure it would fall into a management or administration. It obviously would depend on the terms and length of the lease, etc. But the point is that by granting a lease of the common good land to a particular body or entity, even if it's a sports club, then what the lease would carry with it exclusive occupation, and therefore what the local authority is doing is putting possession and control of that piece of land out with the hands of the population, the populace. So I think it would need to be approached carefully, would need to be looked at.
Thank you both. If we then move on, Alison Mars asked a question, but then I think you'd answered it a couple of minutes later in your talk, Dennis, so we'll skip over that one. The next question is, we have a number of historical leases, e.g. 20 or 30-year leases, where they have an option to extend or purchase, but when entered into, it was not recognised the land was an alienable common good. Would the authority still need to seek consultation in court order if the options were exercised, or would the terms of the lease prevail? I'm going to say, or is that a particularly knotty problem? Again, perhaps Dennis, I might give you that first and then Scott.
That's very, very kind of you, James. Thank you very much. There are a number of interesting points there. First of all, it's arguable, well, the contract's in place already. The option to acquire is in place already. The council is not actually doing anything unlawful in implementing a contract that's already in place. The other way of looking at it is that the council didn't actually have power to enter into that contract in the first place because it was common good land and the consent of the courts required. And therefore, is it possible that the option might be somehow reduced, held to be invalid, unenforceable as a result of the council entering into a contract that was out with its powers?
And you'd have to give some thought to the length of time that had occurred since that happened. Unravelling all such matters may be very problematic indeed.
I think so too, and that's why I was really only quite tentatively dipping my toe into the question of unjustified enrichment, because it could cut both ways. If a local authority has built something on common good land without an intention of donating it to the common good fund, but that's now found to be part of the common good, then is there a case for reversal of an unjustified enrichment in that way as well? It's not always the case that it's a flow from the council into the common good that needs to be addressed. It might be the other way as well.
Scott, do you have a view?
Yeah, I think, well, I mean, it's a tricky one. I mean, I think there are interesting questions about if the land has, on the face of it, been used for a purpose other than the common good purpose for 20 or 30 years because of a long lease. There could be a question of whether a question arises that requires the local authority to petition the court. It may have lost its character de facto as common good land. So there is, I think it would very much depend on the facts of a particular case. But if on a view, you have occupation for a period of greater than 20 years, then you could say the character of common good has gone, and the authority could proceed. The counter to that is to take up Lord Malcolm's point that common good land is property extra commercium. And of course, rights which are extra commercium in terms of the Prescription Act 73 are imprescriptible. Now, I'm not aware of any discussion or any consideration anywhere in the case law of this point. The conventional view seems to be that land can lose its character as common good through a change in use, which is not objected to. And obviously, many local authorities have proceeded on that basis for many years. The separate question, I suppose, is one of remedy. Does an aggrieved person seek to challenge the council's decision to renew a lease by way of judicial review, or do they have other remedies open to them? The reason I mention that is that, of course, if one approaches it by way of judicial review, you've got the 3-month time limit to think about. Otherwise, you're on the face of it time barred in relation to any challenge. The other question is whether this is even judicial review territory. Is it an exercise perhaps in an action of declarator and reduction of the lease as a common law ordinary action? So there are actually some quite difficult technical remedy issues involved, as well as the substantive issue of, is there an underlying common good of the inalienable type in play?
Thank you. Just 2 more questions I think deal with. I'm going to take the second last question first, which I think follows on from what we've just been talking about. Is what if private housing historically has been built in common good land? Might that come back? Might the title of the house owner be called into question? Again, I think one would need to learn a lot more detail about answering that, but for some of the reasons that Scott's gone through, my inclination would be that they're probably safe, but I'll pass that over to Scott first and then Dennis in that order, whether just for a very initial gut feeling reaction to that.
I think they probably would be safe. I think one has to, on the face of it, because of property law considerations. Now, I'm no expert in property law, far from it, but it strikes me if you've got a registered title in the land register to your house, then that's unchallengeable. And if there are extrinsic issues which are of a latent nature, common good character of the land, then I suppose the remedy of it, if there is one, is not so much against the owner of the house, it's against the local authority that allowed a house to be built on that land. Because I have difficulty in seeing a court saying that a buyer in good faith who's paid money for a house from a developer is ever going to be put out of that house or lose their title because of some latent common good consideration, when the real remedy may be against the local authority in question. And that in turn just raises this interesting point of can someone challenge such a disposal many years after its implementation?
Dennis, anything to add to that as our property specialist?
That's very kind of you, James. I think, first of all, that this shows that common good is incredibly difficult, and the number of issues that it throws up is actually quite spectacular. And it's for that reason that, coming back to the Angus case, it's surprising that the majority just took a straightforward property law analysis. And you know, again, without wishing to be critical, there's no real squaring of the circle with Lord Malcolm's opinion. It's just really two different opinions, and it comes down to this question of categorization. Anyway, coming back to the question in hand, I'm going to again try and take the easy, straightforward property law point, which is that if someone has a disposition of land in their favour and they possess that land for 10 years or more, then their title is unchallengeable. They've acquired that title by prescription.
Good, thank you. And then I think the last question, if I've worked through them correctly, is a fairly short one. It's, do you think the duty to consult under the 2015 Act is engaged to establish a common good register where the local authority view is that it doesn't hold any common good land? Would it be required to publish a register with nothing on it for consultation. Peter, I shall just...
I'm putting that one straight to Scott. I'm not even going to engage with that, James.
Right,
yeah.
I'll sort of pass that to Scott whilst Dennis and I play for time while we think of an answer.
Absolutely, yes, I know, you swines. Yeah, it's not something I've ever given any thought to. It's a really interesting point. I mean, my immediate reaction to that is I'd be surprised if there's any local authority in Scotland that doesn't have some sort of common good. I think my reason for saying that is that all modern local authorities will have inherited the assets of a former borough. I can't imagine there is not one modern Scottish local authority that's not inherited the assets of a former borough. And I think if one also takes the view that common good isn't just land, it's other stuff, then including, for example, to take a really obscure point, the regalia of office of the provost is arguably common good, and that's movable property. Now, that may not be terribly interesting from a practical point of view, but as a general proposition, I'd be surprised if there was no common good held by any local authority in Scotland. If you wanted to challenge that, you're probably looking at some form of judicial review action on the basis that the local authority's conclusion is likely to be irrational. The failure itself to publish a common good register on the footing that we don't have any common good, I think on the face of it, from my recollection of the legislation, is that there wouldn't be an obligation to publish a register that doesn't list something the authority doesn't consider it has. But that's a separate question from whether that was a rational conclusion. So I suppose in that situation, an aggrieved person might be best placed to say to the council, well, what about this bit of land? What about this particular item of movable property you hold? Why do you not consider that to be common good? And that raises questions of rationality. And that might be an area where a court might be interested on whether or not the council has rationally concluded there's no common good. And if they fail to do that, then that in turn would trigger an obligation to look at matters again and to consider putting that particular item into the common good. But as a starting point, I find it slightly odd that any authority, hopefully not an authority I act for, in which case I might take a different position, but I find it slightly odd that an authority anywhere in Scotland would maintain that there's nothing that they have which is common good.
Thank you very much for that final answer, and that illustrates just how broad scope common good property could be. So I think those are all our questions. So I was going to first of all thank Scott and Dennis for their very helpful talks. They've borne absolutely the brunt of the work in preparing for today. I hope you all found it helpful. As I indicated, the slides and Scott's background notes will be available on the website, or a link will be provided. Emma will follow up this session with an email with links so you can click through to them directly. I'll remind you of the upcoming other webinars in due course: immigration, employment, property, planning and judicial review. And with that, and thanks again to Scott and Dennis, to thank you for joining, and to wish you all a good day. Thank you very much indeed.